President, I know that I'm shorter than my benefit. The central form of submission will be the proper interpretation of section 84 to paragraph F of the Constitution. Because if our interpretation of the is correct, every possible resistance to the remedial action by the President will follow.
Yeah.
We address that issue also in the context of the debate that has taken place between the bench and our legislators. And as we understand, the logic presiding proposed a number of concerns arising from facts that are common to us about when the President was made aware of the complaint against him by the DA, evolving to when the Public Protector investigated the complaint and ultimately provided his report. And the series of cases that the President has launched in order to examine the legality of that remedial action. Ultimately, we will show that the interpretation that we contend for of Section 84(2)(f does not confer the absolute power of the kind our learned friends contend for. We will direct the court's attention to the express formulation of Section 84(2)(f. We will rely on that formulation to show that that section does not confer the absolute discretion of the kind contended by the President. Far from it, by its own axiomatic formulation, it confers a responsibility. And that's the noun used in Section 84(2). And because it is a responsibility, it must be exercised consistent with the Constitution. We will invoke three interpretational tools to suggest to the court that the interpretation of the responsibility under Section 84(2)(f of the Constitution requires the President to act accountably, requires the President to act responsibly, and requires him to act openly, because those are the foundational values that inform the exercise of public power. We will point to at least two constitutional court injunctions which promote that tool of interpretation. The second interpretive tool that we will direct to the court relates to the purposive interpretation of the statutory provision. At this stage, I need hardly remind the court, given the career of the members of the bench, of the well-known re-examination of the process of interpretation under the Endomeni case. That Judge Wallace's judgment. With respect to him, he pretended to formulate a new approach to interpretation, but he was merely reapprising the well-known approach to interpretation. But the bottom line of one of the key rules of interpretation is that you must interpret a statute in a manner that is purposive and promotes the object of the power conferred. The interpretation contended for by Lenefrin is oppressive to the values of the Constitution, because it means that it will be up to the President in his absolute discretion to decide when, how, and on what terms he will establish the Constitution. The Commission. In this case, the interpretation is even oppressive, because by all accounts, everyone accepts, including the President, that there is a need to establish the Commission. Can I interrupt myself here and ask the court to go to the record to see how the President deals with the necessity the need and the desirability to establish the commission. I ask the court to go to page 433 of the pleadings bundle. It's page 433, paragraph 9.3 of the reply. I merely reference what the President has said in these proceedings and in this court. Our learned friends for the other respondents will excavate other matters of public record where the President had said something about the need for the Commission. We leave it up to them to indicate to the court where else the excavated material would be found. But in this court, the President says to all concerned, in paragraph 9.2, I am still minded to appoint a commission of inquiry, not through dictation, because the issues raised in the Public Protector's report are of sufficient public interest. I rely on that passage to make two points about his version. First, he accepts that the issues raised in the report of the Public Protector are of public interest, not the issues raised in the emails about other persons relating to allegations of state capture. Of course, if he's so minded and believes that the issues raised in the emails also deserve the process of a commission of inquiry, there will be nothing that stops him to include that as part and parcel of the terms of reference. But in this court, by his word, he says the issues raised in the report of the Public Protector justifies the establishment of a commission of inquiry.
Since are you making them within the context of preemption or?
Not at all. I am making them in the context of the power given to him under Section 84(2), which in the context of the specific circumstances of this case implies a duty to fulfill that obligation, that power, to exercise that power. Because it is constitutionally responsive and accountable to exercise that power.
That you advancing falls under the power and duty aspect of
Indeed. I am not going to make any submissions on preemption. I leave it to our learned friends for the other respondents to develop that argument. So that the bottom line for our submission is that in these proceedings, in this court, these words must mean something. And we simply suggest that the President must be taken on the face value of what he told this court under oath. The third tool of interpretation that we will suggest relates to the question whether or not the President is subject to dictation by reason of the remedial action taken by the Public Protector. We will address that issue to show that the remedial action, understood on its own terms, does not dictate to the President. Far from it. They require him to fulfill a constitutional responsibility. under Section 84 2F. But secondly, we will show that the President has a constitutional obligation to assist the public protector to take a remedial action that is effective, because the court would know that under Section 181, subsection 3, all organs of state, including the President, have a constitutional obligation to assist the public protector and ensure that her functions and remedial actions are effective. So when the public protector devised this remedy, he did not purport to dictate to the President. He required him to fulfill the constitutional responsibility, and the President owed a constitutional duty to assist the public protector to give effectiveness to that remedy. We will then address the question of interpretation of Section 82(1)(a) to C in the context of the exchange that has taken place between the court and our learned friends about whether this schematic implementation of the public protector's powers requires her to make a definitive finding of fact for any report and remedial action to carry some legal effect. The bottom line of our learned friends' contention, as we understand it, is that the keystone of validity for the public protector's report and remedial action is a finding of fact. We will take the court once again, and regretfully we will read once more paragraphs A to C of Section 182(1), where we will show that there is nothing in that scheme of investigation and reporting which requires the public protector to make a finding of fact in order for her to report on the conduct investigated. Our learned friend has addressed paragraph 68 to 70 of the EFF judgment. We will reapprise what the Chief Justice has said in that regard to show that what was quite clear is that the remedy or remedial action devised by the public protector must be case specific to a matter investigated by her. He went on to say that the remedy must be situational. In the context of this case, it is quite clear on facts that are common cause that the public protector did not have the time, the resources, nor the capacity to fully investigate widespread allegations leveled against the President and other members relating to the limited concept of state capture. And so she devised a remedy and reported on that remedy. And that remedy, we would submit, is appropriate because it requires a fuller investigation of those allegations.
Maleka, I hear you, and I think I would like you to start right. What the public protector did.
Can I ask
what the Constitution expected her to do?
Can I ask the court to go to Section 182?
Yes.
1 of the Constitution. And then ask the court to read with me, firstly, the preamble in subsection 1. The public protector has the power, as regulated by national legislation, A, to investigate any conduct in the affairs of the state. And the rest is there. Can I pause here that there is no debate between the parties that the public protector did investigate that conduct. What she did not do is to make conclusive findings of fact based on what she has investigated.
She say there should be a commission to conduct a further investigation?
Because she did not have the necessary resources, the necessary capacity, and the necessary funds to make conclusive findings of fact. The court knows that in her affidavit, she says that a proper investigation of those allegations would have required the assistance of a forensic investigation. She did not have that capacity. She says to properly do justice to those investigations, you would require something in the order of 31 million rand. She was given 1.5 million rand. And therefore, she did not have the necessary financial resources.
When you say she investigated, there would be no need for another investigation if she did.
There will be, because think about it, Judge President. Investigations take a different form. Some allegations may be made, and on investigation, they may be put to a person implicated. He or she may admit them, and that will be the end of the investigation. So there is no prescribed one uniform method of investigation. Other allegations may require a commission of inquiry because they would be so wide and extensive in their own implications. And one cannot think of far-reaching allegations such as the one that the public protector had in this case. They go to the very heart and foundation of this constitutional democracy. The public protector could not do justice by simply saying, I look at those investigations, I make findings without properly investigating them, and then dish out that report. Had she done so, she would have suffered the very fate that this court has dealt with in the previous judgment my learned friend has referred to, including
if she had the funds, nothing precluded her from doing that investigation that she wants the commission to do.
If she had funds, she should have dealt with that investigation of her own accord. Yes. If she had access to forensic investigation capacity, she would have done so. If she had the necessary investigators at her disposal, she would have done so. She did not do those things. And what the court would also have to take into account in that score is that she made it quite clear, and everyone accept, including the president, that the investigation of those allegations is a matter that requires urgent attention and completion. So it is not as if the public protector had about, as she said, I will take 4 years if I were to do it myself. Everyone accepts that those allegations must be investigated, and the investigation must be completed with a degree of urgency. It is vital that that matter should be resolved quickly, once and for all, for the benefit of those who are accused and implicated, and also for the benefit of those who are making the allegations. Far more importantly, for the benefit of the public, because it is in the public interest to know whether the democracy that the Constitution has devised and the democracy which electors have reposed in those elected, it is exercised by the true electors and repository of constitutional powers and obligations. So the question of agency becomes vital in the scheme of things. And the public protector does not have that luxury. And that's the reason why she said, I would refer this to the president to invoke his statutory and constitutional responsibility to deal with that matter, and to do so quite quickly. Any responsible president, as you have indicated, would have dealt with that issue quite quickly, rather than do something else, and that is judicial round-tripping through litigation one upon another to prevent the release of the report, to prevent the implementation of the remedial measure itself, where he agrees at least with one part of it, that there has to be a commission of inquiry. That is accountable exercise and responsive and open exercise of constitutional obligations. let me get back to paragraph B, because we have agreed that on paragraph A, there is no uniform measure of investigation. An investigation may take different forms. B says, report on that conduct. In this case, the public protector has reported on that conduct. I accept that she did not make conclusive findings of fact. But there is nothing in paragraph B which says that a report has to be based on conclusive finding of fact for it to be a report, properly speaking, under paragraph B. That is not surprising, because investigations are different. Some investigations may lend themselves to immediate findings of fact, but not all of them. And where, for the reasons mentioned by the public protector, which, by the way, have not been disputed at all by the President in his reply, she reports that I am unable to complete my investigation, but there is a need for a detailed, conclusive investigation. The key question which arises will be paragraph C, whether that report would constitute appropriate remedy. And for the reasons that our learned friends who prepared the heads for the public protector have elaborated upon, I simply submit that that report with this remedy is appropriate. Can I, on that score, Judge President, take you to the passages that our learned friends for the President have referred to of the EFF judgment to illustrate that the report and the remedial measures devised by the public protector in this case are appropriate within the meaning of paragraph C of section 1812. I will be slightly longer than I would have preferred, but let's go to paragraph 69 of where is
authorities.
We have
President's
the
bundle.
President's
What
bundle,
Yes.
page 70. I believe that is page 70 of the President's bundle. And I'm trying to describe the yardstick of appropriate remedy in line with the dicta of the Chief Justice in the EFF case. In paragraph 69, the Chief Justice says the following: but what legal effect the appropriate remedial action has in a particular case depends on the nature of the issues under investigation and the findings made. That is a far cry from suggesting that that statement means that the public protector must make a finding of fact in each case when she investigates a matter. That on its own says that it depends on the circumstances of each case and the issues raised under investigation. Then it continues, as common sense, and I underline common sense, and Section 6 of the Public Protector Act suggests, mediation, conciliation, negotiations may at times be the way to go. Advice considered appropriate to secure a suitable remedy might occasionally be the only real option, and so might recommending litigation or referral of the matter to the relevant public authority or other suitable recommendation as the case might be. We add there the establishment of a commission of inquiry as one of the possible options open to the public protector. Because those remedial measures are infinite, the desirability of them depends on the facts of each case. The legal effect of these remedial measures may simply be that those to whom they are directed are to consider them properly with due regard to their nature, context, and language to determine what course to follow. And I emphasize those to whom they are directed, in this case the President, is required to consider them properly with due regard to their nature, context, environment, to determine what course to follow. Here the President has already told us that the course to follow here is the Commission of Inquiry because of the nature of the issues that arise from the Public Protector's report. 70.
68. 68. Because I think that's where it should start.
At 68, the following is said. Taking appropriate remedial action is much more significant than making a mere endeavor to address complaints as the most the Public Protector could do in terms of the interim constitution. There, the learned judge was describing the type of remedial measure devised for the Public Protector under the interim constitution. It connotes providing a proper, fitting, suitable, and effective remedy for whatever complaint and against whomsoever the Public Protector is called upon to investigate. May I pause here and make the following submissions? 1, it has to be a suitable, it has to be a proper and fitting, but above all, effective remedy. Indeed.
It must be effective.
Indeed. And it is not appropriate. And here one can't conceive of anything that is effective, a remedial measure, other than the establishment of the Commission, because the Public Protector herself does not have the capacity, the money, the resources, and the expertise to carry out the investigation. What is quite significant is that other than to say the matter and the ball must be kicked back to the court of the Public Protector, the President has not suggested any other effective remedy. And that's vital for this court to determine.
Is the remedial action. The final remedial action is this is the way this particular scenario that we are confronted with is to be resolved and remedied.
Indeed.
Is back for further reports to the Public Protector.
Indeed.
This is
Indeed.
action.
And that's why the arguments by Leonard around delegation fail, because the Public Protector has not delegated any power to anyone. So we would not fall into the temptation and run the trap of a delegation. However sensitive, embarrassing, and far-reaching the implication of her report and findings, she is constitutionally empowered to take that has effect if it is the best attempt at curing the root cause of the complaint.
Why, Mr. Semenya, that this is not the remedial action.
It is not.
The remedial action is not complete, as it were. It's necessary to return for a final report to have been valid.
We submit that that is not correct. We can understand if the submission is. We submit that if that's the submission, is fundamentally mistaken.
Mission is, you, Public Protector, must investigate. And once you've done, you've made your finding that this is what I've looked at and this is what I have found. I therefore recommend that the following corrective action happens. The submission is what the recommended remedial action is not corrective action. It's a further investigation that presupposes corrective action at the end of that further investigation.
Yes. The submission assumes that in every case, the Public Protector will have to formally make conclusive findings of fact. We submit that as a starting point, the submission is mistaken because there is nothing in paragraph A to C of section 182(1) that requires the Public Protector to make those findings of fact in order to devise an effective remedy.
the effectiveness of the remedial action, according to the public protector, is to ensure that the complaint is investigated further. What is then the effectiveness? Does it end there?
No. The effectiveness of it is that the Commission will make findings of fact on those allegations that are serious. The effectiveness of it is that if the Commission finds that the allegations are unfounded, the Commission will certainly exonerate the President and all others who are being implicated. That's the effectiveness of that remedy. The effectiveness of it is if those allegations through the process of a commission of inquiries are found to have some evidentiary basis, logically, the Commission will make recommendations on how those findings must be implemented. Because we will be surprised that if the Commission finds that allegations of fundamental breaches of the Constitution, unlawfulness and illegality have been committed, that it will not make a recommendation on how those allegations should be taken forward. Commissions, we know, recommend and tell other law enforcement agents how to give effect to the findings of fact that are made. This is nothing new, it has happened. And that's where the effectiveness of the public protector's remedy lies. It lies for the benefit of the President and those implicated. It also lies for the benefit of those who are complaining, but above all, in the scheme of conflicting personal interests, for the benefit of the country as a whole, that we too, who make these submissions before the court, have the assurance that the state has not been captured in the manner alleged. Can I go to paragraph 17? It is, however, inconsistent with the language, context, and purpose of sections 181 and 182 of the Constitution to conclude that the public protector enjoys the power to make only recommendations that may be disregarded, provided there is a rational basis for doing so. Let me stop here and say that in this case, there is no rational basis for disregarding the public protector's remedial measure, other than the suggestion that the President does not want to act upon dictation. I'll get back to the question of interpretation of Section 84 to show that this is not a dictation. Every complaint requires practical and effective remedy that is in sync with its own peculiarities and merits. It needs to be restated that it is the nature of the issues under investigation, the findings made, and the particular kind of remedial action taken, based on the demands of the time, that would determine the legal effect it has on a person or body or institutions addressed to it. And these are practical measures. These are matters of common sense. These are matters of effectiveness. There is no one single yardstick of the kind suggested by a learned friend that in every case there has to be a finding of fact. I ask the court to note paragraph 71 because it has all the other elements of what is situational. I'm not going to read them. So that the bottom line of our submission, we would submit that the very foundation of the President's submission, that there is a need for findings of fact, it is not supported by the language of section 182, subsection 1A to C. Secondly, it is based on a misappreciation of the dicta of the Constitutional Court in the EFF case. Thirdly, on the facts that are common cause, the remedial action devised by the public protector, absent factual findings on the complaint, is effective as it is necessary, and by all accounts, the need for the Commission is accepted by all concerned, except dictation. Now let me go to the question of dictation. And I ask the court to look at, firstly, the language of section 84(2)(f). Where is the Constitution? I don't know where the Constitution in the bundle of the President fits. It is not there, but it is a short provision. Can I read to the court? It says, the President has the powers entrusted by the Constitution and legislation, including those necessary to perform functions of heads of state and heads of the national executive. And then subsection 2 is quite important. And I ask the court to note the express language used there. The President is responsible for appointing commission of inquiry. Can I pause there and respectfully suggest that the use of the verb responsible by the drafters of this provision was not a mere accident of formulation. It was a deliberate formulation to indicate the true nature of the powers of the President. And we know that in simple English parlance, responsible implies an obligation to fulfill according to the demands of the situation at a given time. This formulation, unlike many others in the Constitution, which give the President the power to make appointments, such as the power to appoint a Chief Justice or a Deputy Chief Justice, the formulation there is the President may appoint, but here the formulation is different, is responsible. So that the debate in this court will be what is the meaning, the parameters and the boundaries of the verb responsible. We respectfully suggest that the court must give content to the meaning of that verb according to the well-known rules of interpretation. The first rule that we rely on is the rule formulated by the Constitutional Court itself in the first UDM judgment. Do you have it? I'm not too sure in the bundle of the authorities where the UDM judgment is. Five? The first UDM. I believe it's 510. Can I reserve my comments? I'll take it up with them after we have made submissions.
5?
I believe that there's a bundle which is now ready to be handed up. I don't want to burden the court with extraordinary paper in addition to the burden that is now facing. It's not a...
To hand up your own.
Yes. Let me not go there because my submissions are fairly straightforward. I'll read this paragraph. It's fairly short a paragraph.
From a judgment of which we don't have sight. 510 of the existing one. Sorry.
It's a judgment that we reference in our heads. Can I tell the court where the judgment will be found?
Paragraph 10.
That's not the judgment I want to refer to.
No.
Can you get me whether you did page 20?
What is the name?
Can I ask the court to go to page 26 of our heads? And ask the court to consider paragraph 34.3. And the court will see that in footnote 79, there is reference to the UDM judgment. Yes. You will see, Justice Hughes, that in that paragraph, those who formulated the heads for the public protector referenced paragraph 83. For the purposes of my submission, I would ask the court to consider paragraphs 18 and 19 of that judgment, because those two paragraphs are vital for how the court should interpret the word responsible in section 84(2)(f) and 19. And paragraph 18 of the judgment says the following. The applicants also contend that the disputed legislation is inconsistent with the founding values of the Constitution. The founding values are set out in section 1 of the Constitution, which provides human dignity, achievement of equality and advancement of human rights and freedoms, non-racialism and non-sexism, supremacy of the Constitution and the rule of law, and D is important, universal adult suffrage, national common voters' roll, regular elections, and multi-party system of democratic government to ensure accountability, responsiveness, and openness. Paragraph 19 says, and that's the Constitutional Code, these founding values have an important place in our Constitution. They inform the interpretation of the Constitution and other law and set positive standards which all law must comply with in order to be valid. They are specially protected by Section 74(1) of the Constitution, which provides that Section 1 may only be amended with the support of at least 75% of members of the National Assembly and 6 provinces in the NCOP. I mean, that's the fundamental importance of these founding values. They are put in Section 1 of the Constitution. They enjoy such protection that you need supermajority to amend them. But of importance is that they set positive standards against which all law and conduct must be measured. In the EFF case, the latest one, what page was it? Page? I believe that it starts at page 60 of the President's bundle. And it's paragraph 1 of the judgment. Page 61. There the Constitutional Court articulated the interpretational tool as follows, and I ask the court to read with me paragraph 1. One of the crucial elements of our constitutional vision is to make decisive break from the unchecked abuse of state power and resources that was virtually institutionalized during the apartheid era. To achieve this goal, we adopted accountability the rule of law, and supremacy of the Constitution as values of our constitutional democracy. For this reason, public office bearers ignore their constitutional obligation at their peril. This is so because constitutionalism, accountability, and the rule of law constitute a sharp and mighty sword that stands ready to chop the ugly head of impunity off its stiffened neck. It is against this backdrop that the following remarks must be understood. I leave the rest for the court to read. But what is quite clear is that the President's responsibility under Section 84(2)(f) are not a mere matter of private power. These are not political powers to be exercised as a matter of convenience and discretion. These are constitutional powers which must be exercised accountably. And you cannot ignore the exercise of those powers because you do so at your own peril. And we rely on this passage to make the submission that in Section 84(2)(f), when the Constitution says the appointment of a commission is the responsibility of the President, the Constitution contemplated that where circumstances require the President to fulfill that responsibility, he has to do so. That cannot be a matter of dictation. And we respectfully submit that in this case, the facts that are common cause require the President to fulfill that responsibility. Because it is common cause that the allegations in this case are far-reaching. Can I interrupt myself and ask the court to look at another part of the President's version in the reply? It is paragraph 8. I'll complete this part of my submission before the lunch adjournment. But paragraph 8 is on page 430. And there the President says the following: to the extent that the respondents rely on the alleged conflict of interest, I may suffer, given that the remedial action seeks to probe my conduct and that of my family, and therefore renders me unable to perform my functions, the functions of the President in relation to the appointment of a commission. The remedial action is unconstitutional. I draw the attention of this court to this paragraph to show that the opposite is true. Section 96 of the Constitution impose a positive obligation on the President to avoid a conflict of fact, a conflict of interest, and a risk to that effect. They also impose the obligation on the President to avoid making use of information in order to benefit himself or other persons. I'm not suggesting that in this case allegations to that effect are founded, but what is quite clear is that allegations of that kind have been raised and require proper probing, because that's an obligation he has under the Constitution, and that is Section 96. Judge President, I see that it's lunch. Can I conclude my submissions on the question of conflict of interest by making the following point? That it is quite clear in this case that the public protector has devised not only a remedial measure that requires the President to fulfill his constitutional responsibility, but also identified aspects of investigation that the Commission has to undertake. We know that the President complains and says that that is a form of dictation that takes away powers from him. But we submit that that cannot be, because it is quite clear that under Section 96, the allegations of conflict of interest on his part must be investigated. And it will be odd that one leaves a discretion to the President to devise the terms of reference when he himself is the subject matter of that investigation. Rationality requires that those terms must be spelled out. Of course, if he wants to add more, like any responsible president would, he is entitled to do so. And so we would submit that that part of the remedial action that set out the terms of reference for the Commission are not only rational, but are effective in order to engage the true nature of the complaint. I'm going to go through two other tools of interpretation after lunch in order to persuade the court that the purposive construction of the word responsible in this case requires that the court should uphold the remedial action devised by the public protector.
Advocate Vincent Maleka for the public protector.